Move your cattle somewhere else. This is a community traffic zone now. Vanessa Pike said it while a paving crew rolled hot asphalt across my private cattle lane. She stood beside her white Lexus in spotless boots, holding up a county permit as though the county seal had turned my ground into HOA property. Behind her, a steel roller pressed black pavement over the route my family had used to move cattle for more than 60 years. Nearly 30 feet of fence had been removed. 2 boundary markers were missing. A new sign faced the Cedar Ridge clubhouse. Cedar Ridge Visitor Turnaround. I looked from the sign to the permit in Vanessa's hand. "Where's your easement?" She smiled. "The county approved the project. You don't get to interfere with permitted community infrastructure." What she did not know was that I had spent 22 years reviewing road maps, property descriptions, and right-of-way records for that same county. A permit could approve the thickness of asphalt. It could approve drainage, grading, and construction methods. It could not give an HOA ownership of the land underneath the pavement. I did not stand in front of the roller. I did not touch the equipment. I photographed the crew, the contractor's name, the permit number, the missing fence, and every machine positioned on my parcel. Then I told the foreman, clearly and on camera, that the owner disputed Cedar Ridge's right to perform any work beyond the recorded boundary. After that, I made 3 calls. The sheriff's non-emergency line, the county permit office, my attorney. By the time the deputy arrived, the crew had stopped laying asphalt. Most of the turnaround was already there, but they did not finish the drainage shoulder or paint the traffic arrows Vanessa had ordered. She thought the county permit would force me to accept the project. Instead, the permit became the document that exposed exactly how Cedar Ridge had placed a visitor turnaround on land it did not control. And when the asphalt was finally cut apart and removed, the crew found something beneath it that Vanessa had insisted never existed. If you have ever assumed that a stamped permit automatically proves ownership, stay with me. The difference between permission to build and the right to use someone else's land cost Cedar Ridge more than the turnaround itself. My name is Ethan Cole. My family has raised cattle on the northern edge of Hawthorne County since 1958. The Cole Ranch covered 420 acres, most of it pasture divided by timber lines, drainage dips, and old fences that had been repaired so many times that no 2 sections looked exactly alike. The ranch was not decorative countryside. Every gate, lane, culvert, and holding pen had a purpose. The cattle lane Vanessa paved began at our southern service gate. It passed the calving barn, crossed a shallow drainage channel, and continued north toward 200 acres of grazing ground. From Cedar Ridge, it probably looked like an unusually wide dirt road. To us, it was part of the working system of the ranch. During calving season, we moved cows between the barn and the sheltered field along that lane. Feed trucks used it when the lower road became too soft. Veterinarians used it to reach livestock without driving through the main yard. If wind dropped a tree across our primary drive, the cattle lane became our secondary farm route. 23 years earlier, a flood had washed out part of it. My wife Ellen and I spent 3 weekends rebuilding the grade, resetting the culvert, and hauling gravel with an old tractor that overheated every 40 minutes. When the work was finished, Ellen carved our initials into the cedar post beside the south gate, EC. She claimed it stood for Ethan Cole. I said it stood for Ellen's construction. That post remained less than 50 feet from the place where Cedar Ridge poured asphalt. Ellen still managed the cattle records and finances with me, though she preferred the office to the tractor, now that one knee had begun reminding her of every winter she had spent working outside. Our daughter Rachel lived nearby and helped during calving season. She worked in agricultural insurance, which meant she understood how quickly uncontrolled public traffic could become a liability problem. I understood land records. Before returning to the ranch full-time, I had worked for the Hawthorne County Highway Department. I began on a maintenance crew and later moved into survey support and right-of-way review. I learned that a road visible on the ground was not always a legal road. People drove across private land for convenience. Developers drew access lines on concept plans that never appeared in recorded instruments. Contractors trusted drawings supplied by clients who did not understand or did not want to understand where their authority ended. That was why I kept copies of our deeds, surveys, utility permissions, drainage agreements, and old fence records in a fireproof cabinet. Ellen used to joke that our office contained more paper than the courthouse, Cedar Ridge had not existed when I was growing up. The property east of our ranch had belonged to the Dalton family. 12 years before the paving incident, a developer purchased it and built Cedar Ridge Estates. The subdivision advertised rural luxury: stone entrance walls, decorative street lamps, large homes overlooking open fields, a clubhouse with a pool, and landscaped event lawn. The brochures praised the peace and character of country living, without mentioning cattle, tractors, early morning feed deliveries, or the smell of manure after rain. At first, we had no serious problems with the development. Its original builder installed a proper fence along our common boundary. Utility access across one corner of the ranch was handled through a written temporary license. Residents waved from the road, and several families brought their children to see newborn calves. The relationship changed after the developer transferred control to the HOA, and Vanessa Pike became board president. Vanessa treated the boundaries of Cedar Ridge as though they expanded whenever the HOA needed something. She complained that my stock trailer was visible from 2 homes. She complained about the metal siding on the calving barn. She once asked whether the ranch had received architectural approval for a replacement equipment shed. Each time, I gave her the same response. The coal ranch is not part of Cedar Ridge and is not subject to its governing documents. She never acknowledged that sentence. She simply moved to another complaint. The cattle lane problem began after the HOA expanded its clubhouse. The renovation added a commercial kitchen, a larger patio, and space for private events. Cedar Ridge began hosting weddings, real estate receptions, holiday markets, and corporate dinners. Those events produced income for the association. They also produced traffic. The residential road near the clubhouse narrowed between a landscaped island and a retaining wall. Catering trucks and longer vehicles had difficulty turning around without backing through an intersection. The HOA's engineer proposed 2 possible solutions. One involved rebuilding part of Cedar Ridge's own parking area. It would have required moving drainage, removing 6 premium spaces, and spending considerably more than the board wanted. The other option appeared cheaper. Open a section of the boundary fence, extend the paved surface onto my cattle lane, and use the ranch as a turnaround. Vanessa first approached me while I was repairing a hinge at the south gate. She stopped her Lexus beside the fence and lowered the window. "Ethan, we need to discuss emergency access." I set my wrench on the gate. "What emergency?" "Our safety committee has identified your lane as a necessary turnaround for fire and medical vehicles." "Did the fire department identify it?" "Our committee reviewed the traffic pattern." "That wasn't my question." She explained that Cedar Ridge wanted to install a gate between the clubhouse road and my cattle lane. HOA management would hold a key. The gate, she said, would be opened only when emergency vehicles needed additional space. I told her I would review a proposal if it came directly from the fire department and included an engineered plan, insurance provisions, maintenance responsibilities, and language stating that no permanent easement or routine access right was created. She looked surprised. "You expect lawyers to become involved over one gate?" "I expect anyone requesting access across a working ranch to put the terms in writing. This would improve your relationship with the community." "I have no problem with the community." Her expression told me she understood the distinction. No fire department ever contacted me. Instead, 2 weeks later, Cedar Ridge sent a letter stating that the cattle lane had been identified as part of a regional emergency access network, and that refusing access could create liability. I called the county fire marshal. He pulled Cedar Ridge's official emergency plan while I was on the phone. The development had 2 approved entrances from the county road. My ranch was not shown as an emergency access route, staging area, or turnaround. He emailed that confirmation. I placed Cedar Ridge's letter and the fire marshal's response in a folder labeled Cedar Ridge Access. Rachel reviewed the situation with our farm insurance agent. The agent sent a short written summary, explaining that repeated public traffic beside active livestock could require additional coverage and could create disputes over responsibility if a visitor, animal, or vehicle was injured. That document went into the same folder. For several weeks, nothing else happened. Then vehicles began using the edge of the lane. One SUV crossed through a loose section of fence and turned around near the calving barn. A catering van did the same thing the following weekend. Then 3 cars from a Cedar Ridge open house entered one after another. I repaired the fence and installed a private farm road sign. 2 days later, the sign disappeared. The screws had been removed cleanly. It had not fallen. I installed a trail camera high on a utility post overlooking the lane, the fence, and the clubhouse boundary. The next recording showed a Cedar Ridge maintenance employee taking down the sign and carrying it behind a hedge. I sent Vanessa a still image and requested that HOA employees remain off the ranch. Her reply arrived within 15 minutes. No employee has been authorized to trespass. The location is believed to be part of a shared circulation area. I sent her the parcel number, deed reference, and recorded survey. She did not respond. A week later, Cedar Ridge streamed a board meeting online. Vanessa presented a proposal called the South Visitor Circulation Improvement. The slide showed a curved paved turnaround beside the clubhouse. The work area was shaded as part of a community landscape buffer. My parcel number was not displayed. Neither was the actual boundary line. A board member named Paul Benson asked whether the HOA controlled the entire work area. Vanessa answered, "The location has historically functioned as shared access." Another member asked whether I had agreed. "We have initiated stakeholder communication," Vanessa said. That was how she described asking for access and being told no. The board approved preliminary design funding. I downloaded the video. 3 weeks later, a survey crew appeared near the south boundary. I walked out and introduced myself. The crew chief said Cedar Ridge had hired them to locate an existing turnaround and several site features. "There is no existing turnaround," I told him. He checked his work order. "That's how the project is described." I showed him the capped iron boundary monument near the corner and the steel witness post marking the alignment beside the lane. Then I showed him our recorded survey. He photographed both. "I'll notify the client that ownership is disputed," he said. "Please confirm that in writing." He did. 2 days later, I received an email stating that the survey company had informed Cedar Ridge that the proposed work appeared to approach or cross a boundary claimed by the coal parcel and that no permission to enter my property had been provided. I forwarded the email to Vanessa and Cedar Ridge's property manager. There could no longer be any honest claim that nobody had raised the boundary issue. The paving crew arrived on a Tuesday morning while I was away delivering 2 breeding heifers. Rachel called shortly after noon. "Dad, there's construction equipment near the south pasture." "What kind?" "A grader, a dump truck, and a roller. The fence is open. Stay on our side. Take pictures. I'm coming back." 10 minutes later, she called again. "They're paving the cattle lane." By the time I returned, the smell of asphalt reached me before the machines came into view. A curved black pad extended from Cedar Ridge's Clubhouse Road, through the missing fence, and onto my lane. The crew had already placed most of the base and asphalt surface. A steel roller moved slowly across the curve. Vanessa stood beside her Lexus with a permit in one hand. I began recording before leaving my truck. The contractor's foreman walked toward me. I gave him my name and told him he was performing work on parcel 14-228006 without permission from the owner. He looked at the plan clipped to his board. We were told the entire work area was controlled by Cedar Ridge. It isn't. I showed him a digital copy of the recorded survey on my phone and pointed toward the permanent gate post and fence alignment. "Where are the 2 boundary markers that were here this morning?" He looked toward the disturbed ground. "I'll need to ask the site superintendent." Vanessa stepped between us. "The county has approved this project." I looked at the permit posted near the equipment. It approves construction based on the application. It does not grant you an easement. The community has already paid for this improvement. That does not make the land yours. She pointed toward the pasture. "Move your cattle somewhere else. This is a community traffic zone now." The foreman looked from Vanessa to me. I told him again, on camera, that the owner disputed Cedar Ridge's right to build on the parcel and that no easement or license had been granted. Then I called the sheriff's office. My second call was to the county permit desk. I gave the technician the permit number, parcel number, and the name of the contractor. I explained that active work had crossed onto a separately owned agricultural parcel and that the landowner had never signed authorization. My third call was to Mark Ellis, the attorney who had handled property matters for our family. Mark gave me one instruction: do not touch their equipment. Tell the contractor the site is disputed. Preserve everything. The foreman shut down the roller while he called his office. Vanessa demanded that the crew continue. He refused until his company confirmed site control. "You have a valid permit," she told him. "I have a client telling me the work is authorized and an owner standing here with a recorded survey saying it isn't," he said. "We're pausing." That single decision prevented the crew from completing the drainage edge and signage, but most of the turnaround had already been paved. Deputy Daniel Ruiz arrived 20 minutes later. Vanessa immediately told him I was obstructing an approved safety project. Ruiz examined the permit. "This is a construction permit," he said. "It authorizes the turnaround. Does the HOA own the land where the turnaround sits? The location has always been shared." I handed Ruiz copies of my deed, survey, fire marshal email, and the written notice from the survey crew. "The pavement crosses my parcel. Cedar Ridge has no easement." Ruiz looked at Vanessa. "Do you have a recorded easement or signed agreement? Our attorney is researching historical access. So no document today? The county approved the work." Ruiz handed the permit back. "A permit does not settle ownership." Vanessa's face tightened. "The HOA paid for this infrastructure. Mr. Cole cannot simply claim it after the work has been done." Ruiz's body camera was recording. I said nothing. He asked her one more time whether Cedar Ridge had a deed, easement, license, or court order authorizing construction on my parcel. She did not produce one. Ruiz explained that he would document the incident but would not force me to allow traffic across disputed private property. He advised everyone not to alter the site until the county reviewed the permit and the parties addressed the boundary. The county permit office contacted the contractor before the crew left. No additional construction was authorized that day. After the machines were loaded, Vanessa stood beside the unfinished turnaround and told me Cedar Ridge's attorney would seek an injunction if I blocked community access. "There is no community access," I said. "There will be." She drove away. That evening I checked the trail camera. At 7:18 that morning, Vanessa and Cedar Ridge's property manager entered the work area with the foreman. At 7:27, Vanessa pointed toward the capped iron monument. 2 workers pulled it from the ground. At 7:33, a loader chain was attached to the steel witness post. The post came free and was moved beside a pile of fencing. At 8:02, grading began. The camera did not record the crew carrying either marker away. It did record the loader pushing base material across the place where the capped monument had stood. I copied the recordings onto 3 drives. One stayed in the fireproof cabinet, one went to Rachel, one went to Mark. He watched the footage twice. "Do not assume the permit application contains the same boundary shown in your survey," he said. "Request the complete file before anything gets revised." The next morning, I submitted a public records request for the application, site plan, ownership certification, engineering documents, staff emails, inspection records, and all revisions connected to the turnaround permit. I also hired Malcolm Reed, a licensed surveyor who had worked on rural properties for more than 30 years. Before Malcolm arrived, Dana Whitmore from the county planning office called me. She was the engineer assigned to review the complaint. "The permit was issued through a streamlined review," she said. "For what reason?" "The project was submitted as resurfacing and drainage improvement of an existing turnaround. The applicant certified that all affected property was owned or controlled by Cedar Ridge, ShioQuest. There was no existing turnaround. That is one of the questions we now have to examine. Does the permit allow them to use my land while you review it? No. A permit does not create property rights. I'm issuing an administrative stop-use notice while we verify the site information." She paused. "I also need to be clear about the limit of our review. The county can determine whether the permit was issued on accurate information. We are not a court, and we do not issue final judgments in private title disputes." "So they can claim an easement and keep this tied up?" "They can make a claim. They still need evidence." The stop-use order arrived that afternoon. No public or event-related vehicular use pending ownership and permit review. A county inspector attached the notice to the temporary project board and photographed it. Unlike the original story Vanessa later told homeowners, nobody authorized me to tear up the pavement myself. The asphalt remained in place. The county froze its use, but restoration would require either Cedar Ridge's agreement or a separate civil order if the association refused. That became our first real setback. The unfinished turnaround cut across the lane at an awkward angle. The fresh asphalt edge altered drainage, and the open fence forced us to install temporary livestock panels. Until the site was stabilized, feed deliveries had to use the lower road, which became soft after 2 days of rain. The ranch continued operating, but the disruption cost money. Temporary fencing, an extra delivery fee, survey costs, attorney time. Vanessa, meanwhile, began shaping the public story. Cedar Ridge residents received an email titled Urgent Safety Access Delay. It said a neighboring landowner had blocked a county-approved traffic improvement intended to protect families and emergency responders. It did not mention the fire marshal's email. It did not mention the recorded survey. It did not mention that Cedar Ridge had been unable to produce an easement when the deputy asked. Cars began slowing near our entrance. Someone left a note in the mailbox. Stop blocking emergency access. Rachel wanted to post the documents online. Not yet, I told her. They think you're risking lives. They have been given one side. Then show them the other side. The county review will matter more than an argument on social media. She did not like the answer, but she understood it. The permit file arrived 5 business days later. It contained 186 pages. The application described the work as resurfacing and drainage improvement of existing Cedar Ridge visitor turnaround. That wording explained how the project had moved through a simplified process. Resurfacing an existing paved or gravel feature did not trigger the same site review as building a new traffic facility beside a separate parcel. There had never been a turnaround. Not paved, not gravel, not dirt. The application included several photographs, but they were cropped tightly enough to hide most of the fence. One showed dry grass beside the clubhouse road and identified it as an existing vehicular surface. The site plan shaded Cedar Ridge's common area in gray. The proposed turnaround was also gray. The legal boundary between the subdivision and the ranch did not appear. My parcel number was missing. The ownership section contained a checked box. Applicant owns or controls all property affected by the proposed work. Vanessa had signed beneath it as HOA president. An email chain showed that the county permit technician had asked Cedar Ridge's property manager whether the entire project was inside HOA-controlled property. The property manager replied, yes. The work remains within Cedar Ridge's maintained landscape and circulation area. The answer had been sent 4 days after the survey company warned Cedar Ridge that the project approached a disputed private boundary. Another attachment came from the design consultant. 2 months before construction, the consultant had written, property line confirmation is recommended before final layout. Existing site information is inconsistent near the ranch fence. Vanessa had received that email. The board approved construction anyway. The file also contained internal planning notes that destroyed the emergency access story without opening a second fraud case. One memo compared 2 solutions to the clubhouse traffic problem. Option 1, rebuilt Cedar Ridge's own parking area, but removed 6 spaces and required expensive drainage work. Option 2 used the adjacent ranch side circulation area for a visitor turnaround at lower cost. The memo estimated that the second option would preserve parking capacity and support larger clubhouse events. Nothing in the planning note described fire engines. Nothing said ambulances required access. The project was a convenience and revenue decision dressed in the language of safety. Malcolm completed the new survey 3 days later. He reconstructed the boundary from recorded control points and marked it with bright orange flags. The flags did not run along the edge of the turnaround. They crossed directly through it. Nearly 2/3 of the paved curve sat on the coal parcel. At its widest point, it extended 19 feet and 4 inches into the ranch. The calculated position of the missing capped monument fell beneath the new asphalt base. Malcolm's report stated that no recorded easement benefiting Cedar Ridge appeared in the title materials he reviewed. It also documented the prior location of both missing boundary indicators using older photographs and measurements. I sent the report to Dana. The county scheduled an administrative permit hearing for 4 weeks later. The notice listed 3 questions. Was the project accurately described as resurfacing an existing turnaround? Did Cedar Ridge own or control the entire work area? Had the application omitted or misstated information material to the permit decision? Vanessa responded through the HOA attorney, Charles Wynn. Wynn did not claim that the permit transferred ownership. Instead, he said Cedar Ridge was investigating whether historical use had created an implied or prescriptive access right. That argument created delay. The county could review the permit, but it could not issue a final ruling on every possible easement theory. Cedar Ridge threatened to file for an injunction, allowing temporary use while the dispute continued. Mark believed the association's claim was weak, but defending against it would still cost money. Then Cedar Ridge sent a settlement offer. The HOA offered $12,000 for a permanent, unrestricted vehicular easement across the cattle lane. Cedar Ridge would maintain the pavement. I would release all claims related to the construction and acknowledge that the HOA had acted under a good faith belief that the site was available for shared access. Rachel read the offer at our kitchen table. They've told residents they already have a right to use the lane, she said. Now they want you to sell them one, for less than it would cost them to redesign their own parking lot. Are you going to counter? No. A permanent visitor easement would place event traffic beside active livestock. It would affect insurance, security, drainage, future land use, and the operation of the ranch long after Vanessa left the board. The cattle lane was not for sale. Mark sent a short response. The Cole family does not consent to public or HOA traffic across the cattle lane. Cedar Ridge must remove the unauthorized construction and restore the affected property. Vanessa described the refusal as unreasonable. Her email to residents said Cedar Ridge had offered a fair solution, but that I was determined to isolate the community. Paul Benson, the board member who had questioned ownership during the original meeting, began requesting documents. He called me one evening. I voted for the preliminary design, he said. I believed the project was inside the landscape buffer. You were shown a map without the boundary. I know that now. Paul had reviewed the internal board packet. It contained the consultant's warning that property line confirmation was necessary. It also contained the memo showing that the turnaround preserved parking and supported clubhouse events. The board was told this was a safety project, he said. It solved a traffic problem. That is not what residents were told. Save the packet. He laughed without much humor. I'm beginning to understand why you keep saying that. Paul provided the documents to the HOA attorney and asked that Cedar Ridge withdraw its easement claim and negotiate restoration. Vanessa refused. She argued that backing down before the permit hearing would expose the HOA to unnecessary cost and make the board appear negligent. By then, the project had become more than a traffic solution to her. It had become proof of her authority. The week before the hearing, Cedar Ridge held its annual autumn showcase. The original event map had routed catering trucks and visitor vehicles through the new turnaround. Because of the county stop use order, the HOA had to revise the plan and keep all traffic on its legal roads. The event still happened. Vehicles moved more slowly. One catering truck had to make a careful three-point turn. No emergency occurred. No ambulance was trapped. No child was endangered. The supposedly essential access route turned out to be exactly what the internal planning memo described: a convenience. The hearing room held nearly 80 people. Cedar Ridge residents filled most of the seats. Several stood along the rear wall. The HOA board sat at one table with Charles Wynn. Vanessa sat in the center. Ellen and Rachel sat behind Mark and me. We had reduced months of evidence to 4 organized binders. The first contained the deed, title material, and certified survey. The second contained the fire access records and written ownership objections. The third contained the permit file. The fourth contained photographs, camera footage, and the sheriff's body camera recording. The county review panel explained that it was not issuing a final judgment on every possible property claim. Its task was narrower. The panel would determine whether the permit had been issued using accurate material information and whether Cedar Ridge had demonstrated authority to perform the permitted work. Wynn spoke first. He said Cedar Ridge had acted to solve a legitimate traffic concern. He acknowledged that the paved configuration was new, but argued that the area had been used informally for vehicle circulation and that the HOA had believed it controlled the landscape buffer near the fence. He did not say an easement existed. Vanessa followed. She described crowded roads, elderly residents, community events, and the need for safe circulation. Then she pointed toward me. One neighboring landowner has refused every reasonable attempt at cooperation and has blocked a county-approved project that serves more than 100 families. Dana presented the permit review. She began with aerial images, one from 5 years earlier, one from 2 years earlier, one from 6 months before construction. Each showed the Cedar Ridge fence, dry grass on the HOA side, and my dirt cattle lane beyond it. No turnaround existed. No gravel pad existed. No shared road existed. Dana displayed the application photograph labeled Existing Vehicular Surface. Then she widened the image to show the full location. The cropped photograph had excluded the boundary fence and most of the cattle lane. The project qualified for streamlined review because it was submitted as resurfacing an existing facility, Dana said. The historical record does not support that description. A panel member asked Wynne whether Cedar Ridge still claimed an existing turnaround had been present. The HOA acknowledges that the paved layout was newly created, he answered. That was the first collapse. Dana then displayed the certified survey. A red boundary line crossed the black turnaround on the screen. Malcolm explained how he reconstructed the line from recorded control points. At its widest point, the paved work extends 19 feet, 4 inches into parcel 14-228-006, he said. Who owns that parcel? The panel chair asked. Ethan and Ellen Cole. Did your title research identify an easement in favor of Cedar Ridge? No. Did Cedar Ridge provide a competing certified survey? Not to me. Wynne confirmed that the HOA had not commissioned one. That was the second collapse. Dana displayed the ownership certification. Vanessa's signature appeared beneath the statement that Cedar Ridge owned or controlled all affected property. The county technician's email appeared next. Is all proposed work within Cedar Ridge controlled land? Then came the property manager's answer. Yes. Dana placed the survey company's earlier warning beside it. Cedar Ridge had been told that the project approached a disputed private boundary before the ownership certification was finalized. Vanessa leaned toward her microphone. We relied on site information supplied by our consultants. Dana displayed the consultant's email recommending property line confirmation. The email had been sent directly to Vanessa and the property manager. You were advised to confirm the boundary, the chair said. We believe the existing fence and maintenance pattern supported the plan. Did you obtain written authorization from the Coles? No. Did you obtain an easement? Our attorney is evaluating several possible access theories. That was not the question. Wynne answered for her. No recorded easement has been located. That was the third collapse. The county technician loaded the trail camera recording. A timestamp appeared on the screen. Vanessa stood with the property manager and contractor's foreman near the south fence. She pointed toward the capped monument. Workers pulled it from the ground. Minutes later, the steel witness post was removed with a loader chain. The room became silent. The foreman testified next. He said his company had received a site plan representing the entire work area as Cedar Ridge property. He said the crew believed the posts were obsolete fence materials inside the project limits. When did you first learn ownership was disputed? The panel asked. When Mr. Cole returned and presented a recorded survey. What did you do? We stopped further work and contacted our office. Did Cedar Ridge instruct you to continue? Ms. Pike asked us to rely on the permit. I declined until site control could be verified. The foreman's testimony did not make the contractor blameless. It did make clear who had supplied the incorrect site information and who had wanted the work to continue. Luis, the fencing contractor who had repaired that boundary the previous year, identified both markers and provided dated photographs showing their locations. Malcolm explained that removing a monument did not move the legal line. It only destroyed physical evidence of where the line had been marked. The calculated position of the capped monument now fell beneath the asphalt. That was the fourth collapse. The fire marshal representative took the microphone. Was the coal cattle lane part of Cedar Ridge's approved emergency access plan? The chair asked. No. Did your office request a turnaround on the ranch? No. Did your office tell Cedar Ridge that the location was needed for fire or medical access? No. Dana displayed Cedar Ridge's earlier letter claiming the lane was part of a regional emergency network. Then she displayed the fire marshal's written denial. Cedar Ridge had received the denial before submitting the permit application. Vanessa said the HOA Safety Committee had independently determined that the route would improve circulation. The chair looked at her. An internal committee may recommend improvements on HOA property. It cannot create access rights across a neighboring ranch. That was the fifth collapse. Mark asked the panel to play a short section of Deputy Ruiz's body camera footage. Vanessa's voice filled the room. The HOA paid for this infrastructure. Mr. Cole cannot simply claim it after the work has been completed. Ruiz asked. Who owns the ground underneath it? Vanessa answered. The county approved the project. Ruiz repeated the question. She never answered. Several Cedar Ridge residents turned toward the HOA table. The body camera video ended. Dana presented one final document, the Internal Alternatives Memo. Option 1 rebuilt Cedar Ridge's own parking area at higher cost and removed 6 parking spaces. Option 2 used the ranch side location to preserve parking and support larger clubhouse events. The words emergency access did not appear. A woman in the Cedar Ridge section whispered, "Then why were we told ambulances needed it?" The chair called for order. Vanessa requested a short recess. During the break, residents gathered around Paul and the other board members. No one approached Vanessa. When the hearing resumed, Wynn made a careful statement. He said the HOA recognized that a permit did not create property rights and that Cedar Ridge would review the panel's decision before deciding whether to pursue any separate civil access claim. Vanessa asked to speak. She said the situation resulted from inconsistent site records, consultant assumptions, and an overly technical permitting process. Dana responded with a timeline. June 3rd, Vanessa requested access from the Coles. June 3rd, Ethan declined routine access and asked for formal fire department involvement. June 18th, the fire marshal confirmed that no emergency designation existed. July 7th, Ethan provided the recorded survey. August 2, Cedar Ridge's survey contractor documented the ownership objection. August 6, the design consultant recommended boundary confirmation. August 10th, the county asked whether Cedar Ridge controlled the entire work area. August 10th, Cedar Ridge answered yes. September 12th, Vanessa signed the ownership certification. September 26, construction crossed the recorded boundary. The panel chair looked at Vanessa. This was not one mistaken line on a drawing. The applicant received repeated notice that site control was unresolved and proceeded without obtaining authorization. Quent. The panel voted unanimously. The permit was revoked because the project had been materially mischaracterized as resurfacing an existing turnaround and because Cedar Ridge had not established control of the full work area. The stop use order remained in effect. Cedar Ridge was required to submit a compliance plan addressing all permitted work outside the land it could demonstrate a right to control. The boundary marker evidence was referred separately to the county enforcement office. The panel did not award me damages. It did not decide every civil issue. It did something more important first. It removed the permit Vanessa had been using as proof that Cedar Ridge could occupy my lane. The chair entered the decision. Vanessa tried to continue arguing. "The decision has been issued," he said. A Cedar Ridge homeowner named Margaret Shaw stood near the rear of the room. She was in her 70s and leaned on a cane. "We were told Mr. Cole was blocking emergency vehicles," she said. "Was that true?" No one at the HOA table answered. Margaret looked directly at Vanessa. "Did the fire department ever ask for his lane?" Vanessa said the board had relied on professional safety concerns. "That isn't what I asked." The room had heard that phrase several times already. Margaret turned toward the other board members. "Why did our assessment pay for pavement on land we did not own?" Paul announced that he would request a special membership meeting to review the board's handling of the project. 2 directors supported him immediately. Vanessa left through a side door after the hearing. 3 days later, the county installed concrete barriers on Cedar Ridge's side of the turnaround. A red sign stood between them. No legal access. Permit revoked. The image spread through Cedar Ridge faster than any email Vanessa had sent. Residents could see the new asphalt. They could see the orange survey flags crossing it. They could see the barrier at the HOA entrance. No legal explanation was necessary. The turnaround went nowhere because Cedar Ridge had never secured the right to use the ground beneath it. After the hearing, the dispute moved into civil settlement. Without the permit and without evidence of an easement, Cedar Ridge's attorney stopped threatening an injunction. The HOA agreed that the association would not claim routine access across the cattle lane. It also agreed to remove the pavement and base material from the Cole parcel, rebuild the drainage slope, restore the fence, and replace the disturbed boundary monument under licensed supervision. Cedar Ridge reimbursed our survey costs, temporary fencing expenses, documented delivery charges, and a negotiated portion of our legal fees. The association did not admit every allegation we had raised. We did not need it to. The written agreement stated that no easement, license, public right, or HOA access interest had been created by the construction. The original paving contract had cost Cedar Ridge $47,600. Removal, drainage restoration, fencing, surveying, and settlement expenses pushed the association's total direct cost above $90,000. That was the part residents understood most easily. The HOA had paid to pave my land. Then it had to pay again to remove the pavement and put the land back the way it had been. The county enforcement investigation continued separately. When the removal contractor cut through the asphalt, a survey coordinator stood beside the calculated monument location. Beneath the pavement and compacted base, the crew found the broken upper section of the capped iron pin. It had not been carried away. It had been snapped below grade, pushed into the stone, and paved over. The trail camera recording, the fencing photographs, and the discovery beneath the asphalt gave the county enough evidence to issue civil citations connected to unauthorized work and interference with a boundary monument. The matter ended with fines, restitution requirements, and formal findings rather than a dramatic arrest. That outcome suited me. I wanted the land restored and the record corrected. The special Cedar Ridge membership meeting took place while restoration was underway. Paul presented the permit decision, the internal planning memo, the survey, and the cost of the settlement. Vanessa argued that she had acted to protect community interests and that the board had relied on professional advice. Residents were less interested in her intentions than in the warnings she had ignored. The vote removed her as president. It was not close. The new board did not launch an investigation into every dollar Cedar Ridge had ever spent. It focused on the failure in front of them. Projects near outside property boundaries would require a certified survey. No work could proceed without documented site control. Any request for access across neighboring land had to be reviewed by council before construction funds were approved. Permit applications had to be circulated to the full board before an officer signed an ownership certification. Those were narrow reforms. They were also exactly the reforms Cedar Ridge had needed. Restoring the cattle lane took nearly a month. The contractor cut the asphalt into sections and lifted the slabs onto trucks. Crews removed the compacted stone, rebuilt the shallow drainage dip, replaced topsoil, and reseeded the shoulder. Malcolm installed a new capped monument at the recorded corner. A bright orange steel witness post protected it. The fence was rebuilt along the certified line. Ellen's cedar gate post remained in place. The roller had scarred one side, but the initials were still visible. EC. We could have replaced it. We did not. When the work was complete, Paul and the Cedar Ridge Fire Safety Coordinator asked to meet. They did not ask for a visitor route. They did not ask for an HOA key. They brought a limited emergency protocol reviewed by the county fire marshal. If Cedar Ridge's 2 legal entrances became physically blocked during a genuine emergency, the fire department, not the HOA, could contact me, Ellen, or Rachel to request temporary access through a designated farm gate. The agreement created no easement. It allowed no routine traffic. It gave Cedar Ridge no independent right to open the gate. Our insurer reviewed it. Mark reviewed it. We signed. Helping during a real emergency had never been the problem. The problem was Vanessa deciding that convenience gave her control. Nearly 1 year after the paving crew arrived, Ellen and I moved a group of cows through the south lane. The grass had returned over the restored shoulder. The drainage held after 2 hard summer storms. The fence followed the row of orange-marked boundary points. The final cow passed the old gatepost and moved toward the north pasture. Ellen rested one hand on the scar left by the roller. "You think the mark will disappear?" she asked. "Eventually." She looked down the lane. "The paper won't." She was right. The deed remained in our cabinet. The certified survey remained in the county record. The permit decision remained public. The camera footage still showed exactly what had happened before the first machine crossed the line. Vanessa believed a county stamp gave the HOA control because the permit looked official. She believed a board vote could convert a cattle lane into community infrastructure. She believed paying for asphalt created a right to use the land underneath it. It did not. A permit can approve construction methods. It can approve materials. It can require drainage and inspections. It cannot transfer private land. It cannot replace an easement. It cannot move a boundary because the applicant left the line off a drawing. And it cannot turn trespass into ownership by placing the word community on a sign. I did not win by shouting louder than Vanessa. I did not damage the equipment. I did not block a roller with a tractor. I documented the work, notified the contractor, called the proper authorities, and organized the records in the order they had been created. The fire marshal's response, the recorded survey, the written boundary warning, the permit application, the ownership certification, the trail camera footage, the body camera recording. No single document carried the entire case. Together, they left Cedar Ridge with no place to hide the easement it had never obtained. A few days after the fence was restored, Rachel found the old private farm road sign behind the hedge where the maintenance employee had hidden it. One corner was bent. We straightened it and mounted it beside the south gate. Underneath, Ellen added a smaller sign. Access by permission only. That was the entire lesson. Property rights do not mean refusing to help every neighbor. They mean help is yours to offer. Access is yours to grant. And no HOA president, board vote, or stamped construction permit gets to make that choice for you. Vanessa paved a visitor turnaround across my cattle lane. The county reviewed the permit. Cedar Ridge produced no easement, and once that missing right became visible to everyone, removing the asphalt was the easy part.